Hello po. Oy, kumusta po kayo? Nung last time, pinag-usapan natin ibang topic. So ngayon, bagong topic naman to, voluntary arbitration. Pero bago po ako magsimula, papakilala po ulit ako. Ako po ay si kasamang Roland de la Cruz, Pangulo ng National Congress of Unions in the Sugar Industry of the Philippines, or NACUSIP. Ako din po ang Senior National Executive Vice President ng Philippine Agriculture, Commercial Industrial Workers Union or PASIWO at Senior National Executive Vice President din ng Congress of Independent Organization. Ako din po ay Executive Vice President ng UNI Global Union, Philippine Liaison Council at ng Trade Union Congress of the Philippines. At General Secretary din po ako ng National Trade Union Center. Likewise ay nakaupo din po tayo bilang labor representative sa National Tripartite Industrial Peace Council at doon po sa Sugar Tripartite Council. So balikan po natin, last time we were discussing about Grievance Machinery at voluntary arbitration. Dapat as part of our education program sa ating continuing education for labor leaders na ginagawa po natin para sa mga member at mga opisyalis ng mga union na kasapi po sa ating iba't ibang organisasyon. So ngayon, dahil hindi po natin natapos last time, masyadong mahaba yung discussion natin sa Grievance Machinery. Today, we will talk about voluntary arbitration. No? Pero wag po natin ito ihiwalay, ang voluntary arbitration sa Grievance Machinery kasi ito po yung dugtong. No? Pag ang isang Grievance Machinery, hindi naayos yung mga problema, yung mga issues between the workers and management, diretso po yan sa voluntary arbitration. So ngayon, today, pag-uusapan natin, ano po yung voluntary arbitration? Okay? So i-share ko po sa inyo yung screen po natin. No? Okay? So here is voluntary arbitration. No? Pag-usapan natin yung voluntary arbitration. Okay. Bakit sinasabi natin voluntary at saka arbitration? Kasi dalawang klase po yung arbitration eh. Meron pong compulsory arbitration. Yan po ay nangyayari dun sa National Labor Relations Commission, sa NLRC. Yung kausap po natin dito, yung arbiter. Pero dun sa Grievance Machinery, anong pinag-iba nito? Doon po kasi sa Grievance Machinery, it's more of a conciliation, mediation. Doon tayo nagko-conciliate ng mga issues. No? Pinag-uusapan, paano natin isolve, paano tayo mag-compromise, paano tayo mag-come up with a win-win solution to address the problem. Pero pag hindi po natin ito na-address, sa level po ng voluntary arbitration, dito po tayo hantong sa level po ng grievance, ang pupuntahan po natin yan ay yung voluntary arbitration. So, marami po sa inyo siguro na hindi familiar with the operations of a trade union and the grievance machinery. Marami po sa atin hindi alam kung ano yung ibig sabihin ng voluntary arbitration. Okay, so let's proceed. Okay. Voluntary arbitration, sabi ng batas, is a mode of settling labor management disputes by which the parties select a competent, trained, and impartial persons who shall decide on the merits of the case and whose decisions in final, executory, and unappealable. Okay. So, hindi lang to person kasi pwede rin tayo kumuha ng persons or panel of voluntary arbitrators. Pwede lang isa, we can select one, but most cases, they want to select at least 3 to compose a panel. Para tatlo po yung magde-decide, tatlo po yung baliktagtaan kung paano nila desisyonan yung isang kaso. At saka mas maganda na rin yun para maiwasan na rin yung unnecessary influence doon sa decision ng arbitrator, which is hindi naman po nangyayari yan normally. Okay, so nagsasabi dito, who shall decide on the merits of the case and whose decisions final, executory, and unappealable. Mamaya po, magdi-discuss natin. Bakit final, bakit executory, bakit unappealable? Okay? So then, it is conducted by a voluntary arbitrator accredited by the NCMB or any person identified or designated in the collective bargaining agreement by the union and management or chosen through the assistance of the Department of Labor and Employment subject to the conditions set forth in the CBA. Kaya po nung simula, sabi natin na mandatory provisions ng isang collective bargaining agreement yung Grievance Machinery at saka Voluntary Arbitration clauses. Kasi po, pag wala yan, hindi yan marirehistro. Because dyan, sa CBA, dyan manggagaling, yan ang guide kung paano natin pipiliin yung voluntary arbitrator or panel of arbitrators na who will be the one to decide the issues of the case. Okay? So, sinasabi dito, accredited by the NCMB. Bakit? Meron po tayong tinatawag na accredited voluntary arbitrators. Accredited din sila ng NCMB. Doon po tayo pipili sa listahan. Or any person identified or designated in the CBA. Kasi may mga CBAs din na nakalagay kung sino yung mga voluntary arbitrators na magiging arbitrator anytime na magkakaroon ng dispute doon sa mga policies ng kumpanya at saka sa interpretation ng CBA. Tapos, minsan, humingi din tayo sa dole o kung wala tayo na-identify, hingi tayo sa dole na assistance kung paano. Usually, ang process dito is sasubmit tayo ng pangalan, union, sasubmit ng pangalan, then management, sasubmit din ng pangalan, then iraraffle yan ng NCMB kung sino yung magiging voluntary arbitrator or panel of voluntary arbitrators. Okay? So usually nangyayari kasi, we don't put in sa CBA kasi malay mo baka ang nilagay nyo na tao doon sa CBA, ayaw na mag-practice ng voluntary arbitration. So usually ginagawa na lang, pumipili na lang tayo sa list doon na binibigay ng NCMB, the list of ABAs who are available. At doon pipili yung union, doon pipili yung management para i-raffle, Para i-raffle at magiging voluntary arbitrator doon sa kaso. So in voluntary arbitration procedure, the aggrieved party or the union is called the complainant, while the offending party or the management is called the respondent. Okay. So, ano yung jurisdiction ng voluntary arbitrators? Kasi marami pong nangyayaring confusion dahil yung mga ibang union na hindi familiar, hindi sila na-train ng kanilang federasyon or independent union sila na hindi sila nakumuha ng mga experts para tulungan sila, dumidiretso po sila, pag merong labor issue, merong employer-employee relationship conflict, doon po sila sa NLRC pupunta. Anong nangyayari? Pag pupunta ka ng NLRC, i-dismiss yun. Bakit? Dahil po sa Policy Instructions number 56, series of 1993, ito po yung public document clarifying the jurisdiction between voluntary arbitrators and labor arbiters over termination cases and providing guidelines for the referral of said cases originally filed with the NLRC to the NCMB. Nakalagay dito, in line with the policy of the Labor Code of the Philippines, to promote and emphasize the primacy of free collective bargaining and negotiations, including voluntary arbitration, mediation, and conciliation as modes of settling labor and industrial disputes, the following guidelines are hereby promulgated. Number 1, termination cases arising in or resulting from the interpretation and implementation of collective bargaining agreements and interpretation and enforcement of company personnel policy, which were initially processed at the various steps of the plant-level grievance procedures under the parties' collective bargaining agreements, fall within, take note, fall within the original and exclusive jurisdiction of the voluntary arbitrator pursuant to Article 217, Paragraph C, and Article 261 of the Labor Code. in said cases, if filed before a labor arbiter, shall be dismissed by the labor arbiter for lack of jurisdiction and referred to the concerned NCMB regional branch for appropriate action towards an expeditious selection by the parties of voluntary arbitrator or panel of voluntary arbitrators based on the procedures agreed upon in the CBA. Okay, so pag may CBA ka, pag organize ka, yung issues are within the original and exclusive jurisdiction of the voluntary arbitrator. So kung pupunta ka ng NLRC, lalapit ka sa labor arbiter, i-dismiss yan kasi sayang din ang oras mo. So dito tayo sa voluntary arbitrators kasi ito yung sinasabi ng batas na avenue. Kasi alam nyo bakit? Mas mabilis eh. So voluntary arbitrator, within 30 days after the submission of position papers, submit for approval na. Alam niyo ba pag nasa labor arbiter yung kaso, pinakamababa 6 months, minsan umabot ng 1 year. Tapos pagkatapos dito naman sa voluntary arbitrators, pag gusto niyo, hindi niyo nagustuhan yung decision ng VA, you can file an appeal or another case before the Court of Appeals na. Petition for review na yan, no? Sa Court of Appeals. Dito na doon naman sa labor arbiter, dadaan ka pa ng komisyon. So may isang step ka pa bago ka dumating ng Court of Appeals. Sa voluntary arbiter, ang decision niya, pwede mo nang questionin doon sa Court of Appeals diretso, hindi ka nadadaan sa komisyon. So, mas mabilis. Okay, no? Mas mabilis. So, please take note, no? Please take note. In issues affecting the provisions of the collective bargaining agreement or company interpretation, implementation of enforcement of company personal policies, if you have a union, you have to go through the grievance process. You have to go to voluntary arbitration and not to the labor arbiter. Okay? Clear? O sige, next. Okay. What is the scope of voluntary arbitration? 1. All unresolved grievances arising from the interpretation and implementation of the collective bargaining agreement. Letter B. All unresolved grievances arising from the implementation or enforcement of company personal policies. C. All wage distortion issues arising from the application of any wage orders in organized establishment. Oh, pati doon sa pag-apply ng wage increase as mandated by the Regional Wage Board. No? Pag-organizing establishment, ibig sabihin pag may union, voluntary arbitration yung pupuntahan. All unresolved grievances arising from the interpretation and implementation of the productivity incentive programs under Republic Act 6971. Letter E. All other labor disputes, including unfair labor practices. That is under Article 262 of the Labor Code. Even bargaining deadlocks, voluntary arbitration yung pupuntahan yan. Assumed or certified national interest cases before any stage of the compulsory arbitration process can be presented for voluntary arbitration, and illegal dismissal cases under Policy Instruction number 56 dated April 6, 1993. Yung kanina yung pinakita ko sa inyo, doon po yung Policy Instruction number 56 dated April 6, 1993. So ito po yung scope of voluntary arbitration. So makikita nyo, medyo wide yung scope niya. No? Wide yung scope niya. Kaya kailangan alamin natin kung yung kaso natin shall falls under the jurisdiction of a voluntary arbitrator. Okay? So dapat bago tayo gumalaw, tingnan muna natin, itong kaso ba to? Is this a grievable issue? No? Is this a employer-employee issue? Is this something that is can the voluntary arbitrator take cognizance of this case? O, di ba? So kailangan natin alamin muna kung ano yung pupuntahan ng kaso nito bago tayo gumalaw, kasi pag gumalaw tayo at magkamali, baka yan pa yung cause ng pag-dismiss ng kaso kung saan tayo matatalo. Okay? So we have to know everything like this. So how does voluntary arbitrator acquires jurisdiction? Diba? So alam na natin, no? Itong case na to, dumaan na to ng grievance, dumaan na to ng individual steps sa grievance process, at saka hindi na na-solve ng parties. So ano mangyayari? So sabi nung Department Order 40-03 and the revised procedural guidelines on voluntary arbitration, a voluntary arbitrator or panel of voluntary arbitrators acquire jurisdiction over a specific dispute upon receipt of the following. So, kailangan may sasubmit tayo. Hindi lang pwede yun. Pupunta tayo dun sa VA. Hoy, VA, nak-nak. May problema kami, ayusin mo nga. Hindi ganun. Ha? There is a process. Okay? At anong proseso na to? Anong mga dokumentong isasubmit, no? Para magkaroon ng jurisdiction yung voluntary arbitrator. Yung mga labor leaders dyan, Grievance Committee, makinig kayo. Okay, number 1. Submission agreement signed by the parties. Ibig sabihin, no, management, no, since na hindi na na-solve yung problema, walang closure, walang compromise, walang win-win, no, both union and management should agree that these issues will be brought to the attention before the voluntary arbitrator. So, what they will do is sign a submission agreement. No? Submission. May form yan. Pwede yan kumuha sa NCMB, meron sila. No? Then, a notice to arbitrate signed by a party to a CBA with an agreement to arbitrate if one party refuses to submit the issues to arbitrate. So, for example, so may issue, grievance issue. Tapos management, parang dinidelay niya, no? Ayaw niyang pumunta ng voluntary. Gusto niya ang issue nandun lang sa level ng grievance. Kasi I don't know kung ano yung underlying reasons for delaying it. Pero if the union felt na justice delayed is justice denied, no? Walang katapusan tong grievance na to at hindi na beneficial doon sa membro na apektado, a party to the CBA can file a notice to arbitrate if one party refuses to submit the issues to arbitration. So, ibig sabihin, kung isang party ayaw magperma doon sa submission agreement, yung isang party, siya na lang yung mag-submit ng notice to arbitrate. Okay? So, after the submission of this submission agreement or notice to arbitrate, the National Conciliation Mediation Board shall appoint or designate a voluntary arbitrator in either of the following circumstances. So, in the event the parties fail to select an arbitrator, or in the event that a notice to arbitrate is served, or the CBA does not name in advance an arbitrator, or the other party upon whom the notice is served does not reply favorably within 7 days from receipt, a party may choose the VAs from the region or from the national level. So, doon sa NCMB, meron dyan silang listahan ng mga AVA, AVA, or Accredited Voluntary Arbitrators. So, pili kayo dyan. No? Pili kayo dyan. Pero kung let's say, for example, in one region, dalawa lang yung available na voluntary arbitrator at saka yung union or any of the parties, hindi sila komportable doon. No? Hindi naman wala sa tiwala, pero wala silang confidence na an objective decision will be promulgated on their case, then they can get voluntary arbitrators from the national level. But definitely, it would entail bigger cost because, syempre, nasa national siya, pupunta pa siya doon sa region para for the conference, no, voluntary VA conference. So, medyo may gastos siya. Pero syempre, ang importante, ang habol mo kasi dyan is to get an objective decision favorable to your cause or to your case. So yan ang proseso ha. The NCMB will appoint or designate a VA or may raffle from the choices submitted if walang identified VA doon sa collective bargaining agreement. Okay? So, yan ang paano mag-acquire ng jurisdiction, paano maging part ng issue ang voluntary arbitrator. Okay? Okay. So, procedure to notice to arbitrate. Diba? Kanina, we talk about submission agreement, no? Permado ng parties, submit sa NCMB para mag-proceed na sa VA. Pero, paano kung yung isang party ayaw mag-submit? Okay? So, ito yung procedure to notice to arbitrate. Para malaman natin, anong gagawin natin? Paano kung si management ayaw pumirma ng submission agreement? Anong gagawin natin? Wala na? No. Mag-notice to arbitrate tayo, pero alamin din natin yung proseso. Paano tayo mag-notice to arbitrate? Okay. So, number 1, the notice is served upon the unwilling party. Meaning yung party na ayaw perma dun sa submission agreement. Copy furnished the permanent arbitrator and the NCMB regional branch having jurisdiction over the workplace. So upon receipt of a notice to arbitrate, after the lapse of the 7th-day period within to respond, the permanent arbitrator shall immediately commence arbitration proceedings. In the absence of a permanent arbitrator in the CBA, yan ang tawag dyan. Permanent arbitrator, if you identified an arbitrator in your collective bargaining agreement. So in the absence of a permanent arbitrator in the CBA, the board or the NCMB or the regional branch appoints a voluntary arbitrator who shall immediately commence arbitration proceedings upon receipts of such appointment. So, ang NCMB na ang mag-assign or iraraffle, depende sa ng parties. Kasi dito kasi ayaw na ng isang party mag-cooperate eh. Diba? Ayaw na. So, kaya tayo nag-notice to arbitrate. So, dire-diretso na kasi alam mo, pag masyado matagal yung proseso, nalolo moral din yung empleyado eh. No? Nawawala na rin yung fire. So, kailangan mabilis. That's why ito yung mabilis na proseso. Okay. So, anong advantages of voluntary arbitration in the resolution of dispute? Okay, sabi ko, number 1, speedy. Mabilis. May timeline. No? Hindi katulad sa NLRC, labor arbiter, medyo matagal. Kasi ang dami nilang kasong hinahawakan. Just imagine mo, not 1 out of 10, less than 1 out of 10 establishments are organized. Just imagine mo, 95% ng mga establishments are organized. So lahat ng mga illegal dismissal cases nila, lahat ng mga disputes nila, takbo yan lahat sa NLRC. So just imagine the traffic sa NLRC. Kawawa yung mga labor arbiter doon. Kaya one of the purpose of this voluntary arbitration, so to declog the dockets of NLRC para mas mabilis yung resolve ng issue. So, anong isang advantage? Number 1, speedy. Number 2, fair. Why fair? Alam mo kasi itong voluntary arbitrators, they are private individuals. They are experts in the field. They are lawyers. They are labor practitioners na matagal-tagal na sila. Accredited din sila. Hindi sila ma-accredit ng NCMB pag hindi sila wala silang integrity, wala silang training. So it's fair. Tapos maganda dito is kung ayaw mo isang tao lang mo desisyon nung kaso mo, you can get a panel of arbitrators. At least 3. Unlike in the NLRC, hindi ka pwede kumuha ng panel of labor arbiters. Isa lang talaga doon. Dito, pwede kang mag-3. So, for example, we're not implying that there's corruption, but example, there is undue influence doon sa isang voluntary arbitrator. May 2 pang magiging objective. At saka mahirap i-influence yung 2 over 3. No, hindi naman lahat yan pwede mo influencein eh. Lahat yan will decide on the merits of the case. So that's why it's fair, because you can have the option to have a panel that will weigh all options available for the parties' objective resolution of disputes. Okay? Then finality of decision. Pag nag-decide yung voluntary arbitrator, final na yan. Unless no, na i-questionin yung decision doon sa Court of Appeals within a time prescribed by law. Mamaya, usapan natin yung gaano katagal from the receipt of the decision of the panel of arbitrators or the voluntary arbitrator, gaano katagal dalhin nung aggrieved party via petition for review yung kaso doon sa Court of Appeals. So, final ang decision. Final. Hindi ka na pwede mag-MR. Wala na motion for reconsideration dyan sa voluntary arbitrator. That's why it's called final. All you have to do is file a petition for review before the Court of Appeals. Okay? That it's economical for both in terms of time, money, and resources. Why? Sa voluntary arbitrator, may timeline yan. Within 30 days from submission for resolution, dapat may decision na yung voluntary arbitrator. Ilang hearings lang yan, ilang appearances lang yan. Mabilis yan. Unlike sa arbiter, minsan naabutin, may mga kaso po tayo, maabot tayo ng 8 months. Umabot tayo ng 1 taon. Kasi puno-puno na yung mga kaso nila dun eh. Puno-puno. Pero itong VAs, hindi to sila busy. Na-manage na yung time nila kasi they can accept or they can decline cases if marami na sila. They can request na, oy, hindi mo na ako tatanggap ng kaso ngayon kasi punong-puno na ako. Pero doon sa labor arbiter, wala akong choice. Dahil si labor arbiter, empleyado ng gobyerno, si voluntary arbitrator, hindi. Okay? That's one of the big reasons why mas na-manage effectively and efficiently ng labor arbiter yung timeline. Okay? Money. Yes, of course. Doon sa labor arbiter, wala namang bayad doon. Filing fee. May mga penalties lang if you want to ask for extension. Ganyan. Dito, may bayad. Kasi, sabi ko nga, private individuals to, hindi ito empleyado ng gobyerno. Pero minimal lang. Usually, lang yan, 40,000 per case. 20,000. Hatiin niya ng management and union. So, union will pay 20, management will pay 20. But, normally, the union doesn't pay anything because the union can apply for a subsidy from the NCMP for the 20,000 pesos na babayaran niya sa voluntary arbitrator. So, yan, no? 40,000, that's the average voluntary arbitration cost. Then, ang 20,000 ng union, pwede niya applyan ng subsidy from the NCMP. So, wala siyang bayad. Okay. Management, bayar mo ng 20 mil, marami ng pera mga employers. Okay? So, then it's an alternative to industrial action instead of mag-rally kayo dyan, picket kayo dyan, madidisturbo yung operations, madidisturbo yung ibang manggagawa na hindi naman sila party doon sa kaso. Let's go to grievance, let's grievance it, let's go to voluntary arbitration para tuloy-tuloy yung operation, tuloy-tuloy yung income habang we're on the journey for quest of justice dun sa kaso ng kasamaan natin. And arbitrable issues are not strikeable as mandated by law. Okay, puro kasi minsan pag ULP na, strikeable na yan. Pag gross violation of the collective bargaining agreement, strikeable na yan. Pag union busting, illegal dismissal ng mga officers, strikeable issue na yan. So, it's a case-to-case basis on this aspect. Okay? So, ito na. Period to render an award or decision in a voluntary arbitration case. So, unless the parties agree otherwise, a voluntary or panel of voluntary arbitrators are mandated to render an award of decision within 20 calendar days from date of submission for decision. 20 calendar days. Or minsan kasi si BA humingi ng 30 days. O 30 days lang, baka pwede 30 days lang kasi medyo tinatapos pa akong kaso. Pero okay na yan. 20 days man, 30 days man, that's way faster than the decision, no, na hinihintay mo dun sa NLRC. Yun nga sabi ko sa NLRC, pinakamababa dun 6 months. Sa experience ko, 6 months. Pinakamababa. Okay? So, if the parties agree otherwise, okay, let's make it 45 days. Based on the request of the VA. Or let's make it 60 days or let's make it 90 days para kung panel, para pag-aralan nila, 3 months. Di ba? Mahaba na yan, wag yan. At least okay na yung 45 days, 60 days okay na yan if it's a panel. So and then for a single voluntary arbitrator, 30 days is okay. No? Kasi ang gusto natin dyan is pag-isipan niya ng maayos yung desisyon, wag mamadaliin. Kasi either way, hindi magiging maganda yung decision pag masyadong mabilis at saka hindi pinag-aralan. Maraming infirmities, maraming questionable na mga arguments. Kaya kailangan maganda na pinag-aralan talaga ng todo. The parties may the parties to a case enter ito na amicable settlement of the dispute pending resolution of the arbitrator. Sagot dyan, a big yes. No? A big yes in the event that the parties finally settle their dispute during the pendency of the arbitration proceeding, the terms of settlement shall be reduced in writing and shall be adopted as the decision of the arbitrator. So, okay. Submission na for resolution, no? Sabi ng arbitrator, okay, please give me 30 days to decide to submit a resolution for the case. So, along that line, hindi pinagbabawal na mag-uusap yung mga parties. Open pa rin. Ganitong kagandaan nito, open pa rin. So, along the line, nagkasundo sila o mag-compromise na tayo kasi kung sino man nanalo dito, happy. Kung sino matatalo dito, pupunta ng Court of Appeals hanggang the Supreme Court. So, medyo matagalan. So, let's na lang. Compromise na lang para win-win tayo. So, pag nagkaroon ng ganung agreement, inform ka agad si VA. Sir, nag-agree na kami. Meron na kaming compromise, no? Nagka-settle na namin yung aming dispute. Ito yung mga pinag-usapan namin. Okay, because, importante yan, dahil yung anong pinag-usapan yung ilalagay yan ng arbitrator dun sa desisyon para to protect the parties from ano mangyayari, di ba? For example, pag hindi mo yan nilagay sa desisyon, baka kang nag-settle na, din yung isang party, mali yata ang ginawa ko. Dahil pupunta na ako ng Court of Appeals. So, mga ganun. So kung ano yung na-agreehan, no, the terms of settlement, ilalagay yan. Isusulat yan dun sa desisyon ng arbiter para maging final na. Case closed. Tapos na. Di ba? Yan ang kagandahan nito. So, paano kung ang desisyon ng labor arbiter ay hindi pabor sa iyo? Hindi pabor sa samahan, hindi pabor sa union natin, no? What do we do to appeal to the decision of the voluntary arbitrator? The appeal to the voluntary arbitrator decision to the Court of Appeals in a petition for review must be within 10 days. Bilis, no? 10 days. Grabe naman. Since Article 262-A of the Labor Code expressly provides that the award or decision of the voluntary arbitrator shall be final and executory after 10 calendar days from the receipt by the parties, as enunciated in the landmark case of NYK Field Ship Management Incorporated versus DABU. This was decided on September 13, 2017 with GR number 225142. Why? Bakit landmark? Bakit landmark? Both practitioners, labor practitioners from the union or labor side or management side should take note of this kasi maraming cases, especially, alam niyo ba na since 2016 and down, earlier, no, ang average winning case ng employer sa sa NLRC or sa NCMB and the VA cases, nasa 40 to 35% lang, 35 to 40% lang. You know why? Because of this one. Maraming abogado na ang tinutunan nila ng basis nila yung rules of court. Kasi nandun sa rules of court, 15 days. Quasi-judicial body, 15 days. I-appeal mo. So, siyempre yung iba, busy, hintay nila yan hanggang on the 15th day pa yan sila magsasubmit ng kanilang appeal. Pagdating doon sa court of appeals, dismiss, prescribed, overtime, overdue, nag-lapse na. Bakit? 10 days lang kasi yan. Kasi the labor code is a special law. Rules of court, hindi yan law. Rules yan ng court. Mas mataas yung labor code. Kaya sa decision nito ng NYK Shipfield Management, pinangalagahan ng Korte Suprema yung provision ng labor codes under Article 262. So tandaan nyo VA decision 10 days lang, hindi 15 days. Okay? Let's say may mga abogado kayo, no, mga union kayo, independent unions kayo, may abogado kayo, na tapos natalo kayo sa court sa VA. Then sabihin no, attorney, kailan tayo mag-file? Sabihin na, attorney, ako na bahala, 15 days pa naman yan. Wait, attorney, hindi, 10 days lang. According sa NYK Field Ship Management case, 10 days na. Sabihin na, attorney, hindi, sa rules of court. Rules of court, 15 days eh. Correct mo siya kasi matatalo ka dyan. Even employers should take note. Bahala sila. They have all the money to hire expert lawyers. So, okay? No, take note Appeal to the decision of the voluntary arbitrator should be 10 days from receipt of decision by the parties. So, if I receive it today, then within 10 days from now, no, start ako ng bilang bukas. Ano ba ngayon? Monday. So, bilang ko Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, Monday, Tuesday, Wednesday, Thursday. Dapat naayos ko na. 10 calendar days not 10 working days 10 calendar days. Kasama ang weekend dyan. Okay? 10 days. Okay. So, dyan nagtatapos po yung maiksing actually this is a continuation of the Grievance Machinery presentation that we have last time. Kaya tinapos na natin Grievance Machinery, and Voluntary Arbitration. So, this is very important kasi if you're in a union, no, it parang ano mo to almusal, no? Almusal mo ang grievance. Kasi diyan tayo nagbibigay ng service sa ating mga members. So it is imperative for any union officer to that matter or union member should know the mechanics of the grievance machinery and the voluntary arbitration. Kasi you should know your rights. You should know the process that will protect your rights. Hindi pwede na iwan mo lang sa kamay ng mga tao na hindi mo alam, at least for the basic lang. Pero sa mga officers ng union, kailangan to. Hindi pwedeng officer ka ng union, hindi mo to alam. It's a disservice to your members, disservice to the people who voted for you to put you in that position if you don't know the basic of grievance machinery and voluntary arbitration. So please, we are extending this online labor education series on grievance machinery and voluntary arbitration to all our union officers. Member ka man ng organisasyon namin o hindi, no? Kailangan malaman mo so that you'll be able to perform your duties effectively and efficiently. Kaya po, sa huli, ulitin ko po, papasalamat po kami sa lahat ng suporta. Ito po ay part ng new normal kasi bawal naman po ngayon magpa-seminar, bawal na po ngayon mag-gatherings. So, we're offering this as an online labor education series to all of our union officers and to our members. So pakiusap ko lang po dun sa mga union officers na makapanood nito, please share this, no? Kasi makakatulong din ito sa pag-educate ng ating ibang opisyales at ng mga members natin. So this is the 5th of the videos. We have the first video, the first 3, no? Ano yun? 3-part video series yun, no? Trade Union Administration and Trade Union Administration and Management, 3 yun, no? Kasi mahaba. Then we have the 4th is the Grievance Machinery video. And the 5th is the Voluntary Arbitration video. So please, take your time watching this. Maiksi lang po ito. Hindi po ito umabot ng 1 oras. You can watch this anytime you want. You can watch this again and again. You can use this as your resource material when you research. So please, no, share this knowledge to others. Lamang ang may lamang. Lamang ang may alam. Diba sabi ng hashtag? Lamang ang may alam. Okay, in behalf po ng Napusip, PASIO and CIO, ito po ang yung kasama, si Roland de la Cruz, ay nagpapasalamat sa inyong tulong at suporta. No? Ingat po tayo. Exercise health and safety precautions. Mag-mask po tayo in public places. Maghugas po tayo ng kamay and observe social distancing. Maraming salamat and God bless you all. Maraming salamat po at ako po ay gumagawa na rin, no? Gumagawa na rin ng iba pa mga educational materials na ipapapanood namin po sa inyo. Siguro baka next we're gonna have a discussion on presentation on termination of employment kasi ang dami po ngayong nawawalan ng trabaho, marami pong unemployed. Alam niyo ba na nasa 5 million na ang unemployment rate dito sa Pilipinas since the start of the COVID-19 crisis. And May alone, nag-register po, itong May and June, nag-register po ng mga 2.9 million job losses dahil po sa pagsira ng more than 100,000 establishments. Ito po ay dulot ng COVID-19. So next time, our next video will focus on termination of employment. Ano ba yung mga matatanggap nyo ng mga benepisyo, paano nyo po habulin yung kumpanya, pagbayad, etc. etc. So happy Father's Day to all of you. Happy Father's Day to my beloved late father, Congressman Atty. Zoilo de la Cruz Jr. Sana po ay guide niyo po kami palagi sa aming organisasyon at sa lahat naming ginagawa. Maraming salamat po and see you in our next series. God bless.